Good afternoon, everyone. Welcome to this discussion on the recent amendments to the Karnataka Land Reforms Act. What I will do first is take 10 minutes and explain the changes that have been made. Of course, most of you will be aware of what the changes are exactly, but I'll spend 5 to 10 minutes on that. And then maybe spend another 10 minutes on the implications of these changes that have been made into the Karnataka Land Reforms Act. We've already received some questions from the participants, so then I will spend another 10-15 minutes answering the questions that have already been received. If you have any questions or comments, please use the chat mode on the Zoom function. And I will try and answer as many as possible before we finish this session. So the last few months have seen quite a few changes in the laws relating to land. And when I say last few months, you can actually stretch it all the way back to November of 2019. When the Land Reforms Amendment Ordinance of 2019 was passed, that amended the Section 109 of the Land Reforms Act, and that of course became a legislation later on, and that initiated some reforms into how industries could acquire land, agricultural land, for setting up industries. What that had done was it had exempted, if you're acquiring land for certain industrial purposes under Section 109 of the Karnataka Land Reforms Act, then it exempted that acquisition process from the applicability of Sections 79A and B of the Land Reforms Act. And I'll come to what 79A and B were. Of course, most people would be familiar with 79A and B. And then that sort of was the precursor to what actually happened on 13th July, when the Land Reforms Act, that has caused quite a bit of political tension in the state, was enacted. And that was the Karnataka Land Reforms Amendment Ordinance of 2020, enacted on 13th July. What it did, it made about 4 or 5 changes. I'll explain the principal changes that were brought in by the ordinance, the July ordinance, and then go through each one of them in slight more detail. So, what are the different aspects of the 2020 ordinance? The first one was on ownership. So there's a significant change now into who can own agricultural land in the state of Karnataka. Second, on sealing, what is the impact, what is the extent of lands an individual or an organization can own? There's been an amendment to that. But there has been no change in terms of use. And this is important to remember for those of us who may be interested in understanding how this amendment affects industries. Will industries be able to freely set up industrial activity on any land they want? The answer is no. You still have to go through the change in land use that legislation, that regulatory regime continues. What has changed is the ability to acquire land, the removal of sections 79A and B. Now, what is 79A and B? 79A and B essentially said that only certain kind of people can buy agricultural land. Who were those? They were people who were already involved in agriculture and who did not have an income of more than 25 lakh of rupees from non-agricultural sources. So such people alone could buy agricultural land. Everybody else had to either go through a special purpose under section 109, where they had to seek government approval or the district collector's approval to acquire land for particular purposes. So the removal of 79A and 79B essentially means that there is no restriction on people buying agricultural land in the state of Karnataka. So anyone, whether it is an individual, an organization, or anyone else, can today buy agricultural land freely. If there is a willing seller, they can go and buy agricultural land. But what can they do with that land is something different, because what they can do with that land is actually conduct or practice agriculture. If they want to use land that is currently being used for agriculture for some other purpose, then you have to go and apply to the government for permission to change the use of land. So you cannot just go and buy agricultural land somewhere and set up a factory. That is something that is not allowed, even with the ordinance that has come out in July. The second change that has happened is on the ceiling. So there is, section 63 has been amended, whereby the limit of ownership on agricultural lands has been revised. So if it is, and there is a slab structure, it's the Act talks about units, and what is a unit is also defined in the Act. There's a schedule which specifies the unit. The unit, the classification depends on whether the land is irrigated or not. So there is Class A land, then Class B land, and so on and so forth. And unit is linked to the nature of the land. So this requires a bit of detailing and understanding. So there is a limit of, broadly, one unit is about 40 acres or so, broadly speaking, but that can change based on the the kind of land that you're talking about, whether it's Class A, Class B, and so on, and the nature of how it is calculated. So you should get that checked before you jump to conclusions as to how much of the land that you can buy. But the ceiling has been revised. So what was earlier 10 units for an individual has now been made 20 units. That is, if it's a family of 4 or less. If it's a family of 5 or more, then it has become 20 units. If it's a person who is not a family, so individual or sort of entities, then it's 20 units. So, so for companies, you're not part of a family. I mean, it is about 20 units, and 20 units roughly translates to X number of acres, and that calculation is also available in the Act. So the ceiling has also been changed to the extent that there's an upward revision, and therefore you're able to buy more land than what you could own earlier. Now, those of you who remember the history of the Land Reforms Act, you'll realize that the Land Reforms Act was passed with two purposes in mind. One was to ensure that people who actually tilled the land, or the owners of the land as far as agricultural land was concerned, and second, also to ensure that there was no large-scale land holdings and land was distributed more fairly. That's why the concept of ceiling is important, and there was restriction on how much an individual or a family could own in terms of extent of land. So there was a certain ceiling earlier, and now that ceiling has been revised a bit. Two is ownership. As I already mentioned, today it's more free flow in terms of ownership. You can sell to anyone that you wish, and anyone can purchase agricultural land. Three, in terms of the applicability of this amendment, and that is where I think there is going to be some amount of disruption and dissonance, because the way the ordinance has been structured is that the ordinance says all these amendments will be deemed to have been enforced from 1974. And 1974 was when some of the original amendments were introduced, had been introduced in fact. So what it does is it creates fiction that 79, it's as if 79A and B never existed in the first place from 1974. The reality, of course, is otherwise, in the sense that 79A and B existed, they were implemented, and there's a lot of litigation that's going on in the courts and before the revenue authorities across the state of Karnataka. Now, there's also a provision in the ordinance which states that the existing litigation, this litigation that's happening currently, will abate once this ordinance is enforced. Now, all of these provisions, particularly in terms of retrospective application, could lead to future litigation as well, because retrospective application is something of law, is something that you don't do very easily. Retrospective application is normally done for a particular reason. So it is not clear from the ordinance itself as to how this retrospective application will work, because if you had some cases pending under 79A and B over the last 20 years, for example, if you had purchased certain land, it was taken away from you, and then and distributed to someone else, it's not as if those cases will give you more rights, because there's a provision as well says that if a decision has already been made, then that decision will not be changed. But the fact that this amendment is deemed to have been implemented in 1974 itself does cause some concern, and I think it will lead to litigation as such. Of course, the retrospective application on its own could be challenged in the courts, and what the courts will do will be dependent on how strongly the challenge is put forward. So that is in my view, a wait and watch approach. I have my own views on whether a law should be retrospective or not. The answer is no. Generally, no civilized country wants to have retrospective application of laws because it causes uncertainty. So this is an aspect that needs to be, I would say, wait and watch, because we want to see what the courts will do. And I think unwittingly, the government may also have opened the doors for challenge on the basis of this ground alone, on the basis of retrospective amendment alone. Now, leaving that aside, leaving the retrospective amendment aside, now if we come back to what is happening to the ownership, and what happens to the nature of agricultural land, the nature of agriculture itself, and the impact on industrial activity. Now, acquisition of land has been a very contested space in this country. Every time a project is announced and land is acquired, then inevitably there is a litigation in terms of compensation, in terms of the acquisition itself, in terms of what the project is for, and all of that. So setting up an industry freely, where land was a primary component of that business, was not an easy task, because acquisition of land meant doing many things and jumping many hoops. Now, while to some extent there is relief because of this amendment, because companies and individuals, educational institutions, and others can now go and acquire land freely, because there is also a restriction on the usage of land. And for change in land use, you still need to go to the government. I think there is still there is no free setting up of industries or free conversion of land use, as some people believed that this ordinance would lead to. So that is a point to be remembered. Now, the second point is that there's a particular kind of agricultural land. There is Class A agricultural land, which is linked to irrigation being available or not. Now, that land can only be used for agricultural purposes and can never be used for anything else. Now, why do I say that? That is because of a small amendment in Section 80 of the Act, where earlier, if you were buying land, and you had to provide a certificate saying that you will use the land for agricultural purposes alone. Now that requirement is now limited only to certain kinds of agricultural land, which is a Class A agricultural land. That is the impact of Section 80. Now we'll have to see how this plays out in reality, because there is a discretion with the local deputy commissioner to exempt based on certain undertakings given by the acquirer. So we'll have to see how that works. Now, so in terms of impact, if we were to see, okay, what is the impact now of this? Is there can anyone buy agricultural land? The answer is yes, as of today. One of the questions that people have sent me already is there a domicile requirement that is within the state of Karnataka? The answer is no, there is no domicile requirement within the state of Karnataka for buying agricultural land. Two, there was also a question on whether people outside India can buy agricultural land. Now that is a matter that is regulated by the Foreign Exchange Management Act, the FEMA, and that those conditions will apply. There are restrictions on people not resident in India being able to acquire agricultural land, and the FEMA restrictions and guidelines and regulations will continue to apply to people who are not resident in India. Now FEMA doesn't the test is not citizenship, but the test is residency under FEMA. So to the extent that you are regulated by FEMA, you will not be able to bypass that because of the amendment that has come now through the ordinance. Now the second question, I'm now going through the questions and clarify through the answers that I give to these questions, clarify some of the points that I may have missed earlier. I also note that there are many other questions that have come up while I'm speaking. I'll come to that after I go through the questions that came yesterday. So let me go through these questions. The first question I already answered in terms of domicile requirement. There's no domicile requirement. Can private companies buy agricultural land? The answer is yes. They can buy agricultural land because 79B is now being removed. 79B is what imposed restrictions or what prohibited companies and others from buying agricultural land. 79A was the restriction on individuals and not having non-agricultural sources of income, whereas 79B prohibited certain organizations like companies, religious organizations, educational organizations from buying land. So that is gone. Keen to learn the implication for the commercial property developers as to whether there will be more lands available in the market due to this amendment or not. This is not an easy question to answer. As I said, it is now you're now free to buy any land that you want. However, whether you can use that land for commercial development or not is a factor of the planning laws in the area, the conversion of land use laws, and all of that. And that is still a regulated sector. So you can't do whatever you want with the land that you buy. If you want to do agriculture, and even if you're not somebody that was involved in agriculture earlier, then you can do that. If you're a company if you set up a company to carry out agriculture, then you can do that. However, if you want to acquire land for setting up an industry, then you have to go through the Section 109 process, and you can't just do something on your own, or you have to buy land and obtain a conversion of land use if you want to set up an industry or do something that is non-agriculture in capital. Then need to have more clarity on the requirement of government orders or allotment letters for renewable projects with central grid connectivity. I don't know what the question is, not very clear, but really there is no, what this talks about is land ownership and the ability to buy or sell land. If you're from particular industries, and what other conditions that get up, that are applicable, then those conditions will apply. I mean, so this one does not do away with the conditions that the government may impose on you when it gives permission to acquire land under 109, for example, or any other conditions you may have to satisfy as part of the as in here as a renewable energy policy. Those are different policies. The ordinance doesn't deal with all of that. Then would like to understand from IT companies' views to start development centers. As I said earlier, land use is something that the ordinance does not impact. I mean, for land use, you still need to go and comply with the planning laws and with the rules and regulations that apply to conversion. There was also a question that came in by email this morning asking what impact does it, what impact does this ordinance have on farmers? Will the livelihood of farmers get affected? And will this have an adverse impact on agriculture? Now, unfortunately, I am not an expert on that. But what I do know from having read quite a bit on the agriculture sector, I mean, the agriculture sector is in crisis for various reasons, and whether this will adversely affect that or positively affect that, I'm not in a position to answer that question. But there have been people who have raised concerns about this ordinance from the livelihood of farmers perspective, and they believe that this will destroy agriculture. But it is something that needs to be discussed in some other forum. What it does, though, and this is one thing that I would say, that it does, because this is part of the Land Reforms Act, the amendment seems to go against the original intent of the Land Reforms Act. Whether the government, when it brings this ordinance to the legislature and get passed, because they have to do it because it's only an ordinance and not an act, not a statute, because it's not been debated in the legislature. Maybe they will bring it in a more holistic manner and address some of the questions that have come up over the last few weeks. Now, those were the questions that I had received yesterday and this morning. Now, let me see whether what questions we have today. If I convert the land from agriculture to non-agriculture, will I be free from the ambit of all restrictions in Land Reform Act, and I can purchase the land after conversion and start work ASAP? I mean, there is no clarity on what work they're talking about. But see, I mean, there are two things, and I at the sake of repetition, to buy agricultural land now, there is no restriction. So you can buy agricultural land now. After the ordinance came into picture, if there is a willing seller and there's a willing buyer, I think you can buy agricultural land. What you can use it for is a different issue altogether. And as I mentioned, you cannot buy agricultural land and go and set up a factory on that immediately. You cannot do that. You have to follow whatever processes the state has in terms of conversion of that land. So there are a couple of questions on that. What is the role of Udyoga Mitra under the new amendment? Udyoga Mitra under the new amendment, there is still this particular amendment. There is a July ordinance does not deal with anything to do with Udyoga Mitra. The under 109, there is still a single window clearance. So to that extent, there is some relevance, but there is no impact of this ordinance on any industrial permissions as such. So this is only the ability of this, the impact of this amendment is only that it allows you to buy agricultural land. And as long as you're using it for agriculture itself, there is no problem. Also, the extent of the land, there is a ceiling that applies, continues to apply. The ceiling is being revised upwards, but it applies. However, if you want to buy agricultural land and use it for something else other than agriculture, then there is a restriction, and you have to follow the existing conversion guidelines, before you do anything of that sort. Can a cooperative be formed between friends and buy agricultural lands? The answer is yes. You can buy agricultural lands. If if you come together and buy agricultural land and want to continue doing agriculture, then that's possible. If I want to build agricultural land and build a farmhouse, how big a farmhouse am I able to build on 1 acre of land? Is there a ratio? See, there are no ratios on this thing. You can build a house on agricultural land, but if you're living there and if you're continuing to till the land, but you can't. And what you're essentially then doing is you're having can you convert it into and make it plots and make it residential plots? The answer is no. But if you're tilling the land, if you're doing agriculture there, and you also build a small house there, then the rules do permit it. You have to go and check the rules. It also depends on which area you live in. You need permissions from the local revenue authorities and from the Gram Panchayat. There are many other restrictions that apply. So there is no ratio as such that is being laid down in the ordinance. So the regular rules will continue to apply. There is no, what shall I say? There's no guarantee that people will, just because of this ordinance, all the other rules go away. That doesn't happen. Since it is only an ordinance, will they revoke in case farmers go to court? There is a possibility of that. This is only an ordinance. Whether the government will actually bring it into the legislature and pass the statute, we cannot gaze into the future. But the assumption is if they have there's a very far-reaching change, and if they have brought this, the assumption is that they will actually introduce it into the legislature and try and pass this. That is something that we can only wait and watch. Will they revoke it in case farmers go to court? See, there are two separate questions, right? People will still go to court and challenge some of the provisions. I mentioned that one area of challenge could be the retrospective application of this law. Generally, as we all know, as lawyers know, that to declare a statute unconstitutional, it needs to pass a certain threshold, so that people will have to make their case out in court. Whether government will withdraw this ordinance because farmers go to court, I don't know. I'm assuming that the government will introduce this bill, this ordinance in the form of a bill in the legislature when the legislature is called to session. I think Karnataka legislature the session is expected to start sometime next month, and they have to introduce this in that session. Sorry, 1 second. With ordinance, is it safe to buy though law hasn't been passed? What if the next government changes all this? See, any law can be changed at any point of time, right? So, and this is the point that I was making in connection with the retrospective amendment of the law. Now, if some government, if the next or if this government itself does not, ensure that the ordinance becomes law, then whatever has happened during these months or days when the ordinance was law does get protected. But because they have made a retrospective amendment of this ordinance itself, what they will do is they actually change some of these provisions. I don't know. So if you want to be 100% safe, then you may want to wait till this becomes a law. But the ordinance is law. You may want to wait till it becomes a statute. So that is something that it's an individual choice that you need to make. But there is a problem that if the law doesn't come through in the legislature, then what happens? If that uncertainty is something that worries you, then you may want to wait till the bill becomes statute. Now, what is the maximum amount of land, of agricultural land, that a company can hold? Can directors independently hold agricultural land and lease it out to the company without getting counted against the land holding of the company? No, the answer is the ceiling limits are very clear. The ceiling limits have been revised upwards. As I mentioned, it's 20 units now, for a company, and 20 units, translates, depending on the nature of land, it translates. So each unit is about 40 acres. So the leased land, will it come within the ceiling? The answer is yes. I mean, because you will be, you will be a tenant. But why would it? The question is not very clear. Can directors independently hold agricultural land? The answer is yes. That will be an individual capacity. Can the company hold agricultural land? The answer is yes. There is no problem with that. So I don't know what the question is. Without getting counted against the land holding of the company, the companies, as I said, the ownership is different, and the terms of how you want to enter into that arrangement but it will still be subject to the rules that have been framed. What we need to do is wait for some of the rules to come out, from the government before some of these things can be clarified. Is there any way we can get a certificate from government stating that we are farmers if we seriously want to get into agriculture? See, there is no certificate as such. I mean, the certificate is what we call the RTC, right? I mean, the RTC reflects if you're actually tilling the land, if you're there, the RTC reflects your name. Then that is currently the proof to show that you're involved in agriculture. So if you're actually doing agriculture, then that is the certificate there is. But you don't need this anymore after the amendment. If you want to buy agricultural land and you want to do carry on agriculture, you don't need any certificate currently. So I don't know what the thought process behind this question is. Okay, let me go to the next one. I don't know what would be the significance of this ordinance. I don't know what do you mean, but it is a fairly disruptive ordinance in the sense that it does sort of undo a number of things that have been in practice over the last few decades. So to the extent that it changes the framework of ownership of agricultural land, it's fairly significant ordinance in terms of impact on society, not only in terms of impacts on industry and agriculture and other things, but even in terms of impact on society. Because land ownership is something that is valued very dearly by many people in society, particularly given the history of our land reforms legislation. This is a significant piece of legislation. So what would be the significance? I mean, it's very significant. We are discussing that over the last 40 minutes already. So in case of mortgage, I think in case of mortgage now, since the company can purchase the agricultural land, it can be further deemed converted for non-agricultural use. Can we enforce the land under SURFACE Act? See, the answer is there are certain, actually, it's an interesting question. Let me come to that provision. We can read through that provision, the amendment, and discuss this. One second. So the if the land, see what has happened is in section 80, B has been omitted, clause B. Now clause B is what prohibited the mortgage of any land or interest therein, no mortgage of any land or interest therein, in which the possession of the mortgage property is delivered to the mortgagee. Now that has been removed as such. So technically the answer is yes, you can enforce under SURFACE Act. You can actually enforce the mortgage, provided all the other conditions are met in terms of land use, in terms of what the purpose for which it is used and all of that. However, you should remember that the ceiling will still apply, right? Because if the person who owns the land after the enforcement of SURFACE, whether you're acquiring it yourself or you're selling it, the ceiling will still apply to that particular person. So you should remember that. What is the typical timing of an ordinance becoming part of the legislature? I'm guessing I can go ahead and buy agricultural land based on the ordinance. Yes, you can go ahead and buy agricultural land based on the ordinance. When does an ordinance become a statute? When it is presented before the legislature and it is protected and it is passed by the legislature. So depends on when the session comes up. There is a time limit in terms you have to present it in the session that immediately comes up. Otherwise, you will have to pass a new ordinance as such. So the ordinance is law as of today. Does this law protect previous transactions or only applicable on purchases since the day of ordinance? Now, this is the thing that is a source of confusion, because the deeming provision that this ordinance has brought in, which essentially means that that the 79A, B, etc. have been removed from 1974 itself. So technically, it does protect even previous transactions if the previous transactions have already not been challenged in court and have not been found illegal. So if you have done a transaction, say last year, and 79A and B proceedings have not been initiated or have been initiated but not decided, you could benefit from the ordinance. Now, the next question is would there be any impact on saleability of the land purchased under section 109 route because of this ordinance? No, the answer is no. There is no impact on saleability. I mean, if you are free to sell under the 2019 ordinance, that addressed the 109 issue, and that land can be sold provided you satisfy certain conditions. So if you have gone under the 109 route and you have been exempted from the ceiling limit and all of that, and conversion has been permitted, then you have to comply with that. So it doesn't become freely transferable. You still have to comply with the 109 conditions, which is what the 2019 amendment ordinance did. So you have to comply with that. Now, is one unit, what is one unit? Now, 1 unit means 1 acre of A-class land. To clarify, what is 1 unit and what is 20 units? 1 acre of A-class land, which is above 50%. As I said, you need to look at the schedule very clearly, and this is the definition. I'm reading it out for everybody's benefit. Unit means 1 acre of A-class land, the soil classification value of which is 50 paise and so on and so forth. So yes, the question is correct. It is not 40 guntas. 1 unit is 1 acre. So what is 20 units is the question. So 20 into 1, so it becomes 20 acres. Sorry if I said it was 40 acres. Apologies for that. Now, certificate, so that I benefit, if I buy and genuinely do agree activities tomorrow, if rule changes, they can't confiscate as I will be a farmer I don't know. I mean, the question is a bit garbled. So sorry, I think there are too many questions coming through, so the window is jumping. See, you don't get a certificate, as I mentioned, you don't get a certificate as such that you're conducting agricultural activities. If you're actually conducting agricultural activities and there's no land use change, then there is no problem. You can buy the land for carrying out agriculture. How does this affect properties in the green belt? As I said, land use has to be permitted. If you want to change, from agriculture to some other purpose, you can only do it if the planning laws are permitted. So the green belt, if conversion is not allowed, then you can't do anything else. You can buy land and you can carry out agriculture. Okay, sorry, there's one more question which I'm unable to read. It's a bit garbled. 1 second, please bear with me. If I buy based on ordinance and do agricultural activities, will I be able to hold even if ordinance doesn't become law tomorrow? So the my guess is you will be protected. So suppose the ordinance doesn't become law, then to the extent for the period of time that the ordinance was in force, you can benefit from that, from that period. And if you have bought land validly, then it's very difficult for some other deeming provision to come and undo this particular effect. And there's enough case law to suggest that if your rights are being taken away retrospectively, then that is something that cannot happen, and the courts will come to your aid. So the answer is yes, if you are likely to benefit. And again, as I said, these days legislatures and the governments are getting very creative in how laws are being passed. And this particular, ordinance itself, as I mentioned, the retrospective application is a problem. So I don't know what kind of laws will come, but as the law stands today, if retrospectively a law comes and adversely affects your rights that have already accrued, then that is a ground for challenge on that retrospective application as such. So that is all I can tell you on that. I mean, I don't know, as I mentioned, what kind of laws will be passed. Now, where a power company want your suggestion on right and efficient way of land acquisition, as I said, these are specific questions. If you have specific questions, please write an email and we can try and answer that. But the impact of this legislation, of this ordinance, is that you are now able to buy land and agricultural land and to carry out agriculture. For changes of land use, you have to wait and go through the process. So for 109, if you are doing, if you need to follow the process in 109 or in section 95, so which route is better? It depends on what kind of where the land is located and what the extent of the land that you are acquiring. So we will have to see what what your particular use is as such. So please write separately. I won't be able to get into delay. I won't be able to get into specifics on this call. Does this also mean now we can take loan to buy agricultural land? Well, I mean, if there's somebody willing to give you this is a question of between the banks and you. The banks will have to take a view on whether they want to give security. They want to take security over agricultural land. That is something banks may not be willing to do, because what will they do with agricultural land is a question. Unless banks don't want to get into agriculture, right? So this is a question that the banks have to think about and come up with an answer for. They may take security over it, but whether they give loans only to buy agricultural land, it's really a question of you're asking the wrong person. I'm not a banker. Okay, so you have to wait for the banks to come up with some clarifications on that. Now, there's one more question on the email, which is asking, do you think this is a good ordinance? I mean, won't it adversely affect farmers? Isn't it against the spirit of the Land Reforms Act, the original Land Reforms Act? It is arguable that this goes against the spirit of the land reforms movement that was started, even pre-independence, actually, because this was one of the giving ownership of the land to the person who actually tills the land was a big principle of the freedom movement, and then the laws that came into force later. And this is something that is enshrined in our constitution as well, in terms of equitable distribution of land resources is something that is enshrined in the directive principles of state policy as well. So to that extent, yes, there could be a challenge and debate, but note that there are many other states which already have such free transferability of agricultural land, and Karnataka is not the first state to pass to come up with such an ordinance. Tamil Nadu, for example, there were not, compared to Karnataka, there were no restrictions on buying of agricultural land. So, but whereas in some other states, there are still restrictions. Say, for example, Himachal Pradesh, there are restrictions on, on who can buy land in Himachal. There are domicile restrictions also. So, different states have taken different routes, and whether it goes against the spirit of equitable distribution of resources is something that we'll have to wait and see. Because I was telling this in another forum that I was speaking at, that land is a finite resource. You can't invent land, right? You can't make up land. We're stuck with the finiteness of land. So land ownership and land and transfer of land will always be a very, very emotive issue, and not something that can be taken lightly. So we have to keep that in mind. I think that's it. I don't have any other questions. Let me just see if there's anything else. No, I think I've gone through all the questions. I'm sorry if I missed anything. The questions keep jumping quite rapidly. We'll be happy to answer any questions you may have. If you send us an email, then we'll be able to answer any other questions that you may have. To sort of summarize what the 2 points that I made earlier at the beginning and then throughout the webinar is that what the ordinance does is free up land ownership, ownership in terms of agricultural land. It does not, change anything in terms of land use. For land use, you still have to follow the other rules and regulations. There is an easing in terms of ceiling as well, as to what the amount of land you can hold. There's an easing in terms of ceiling. So it does make it easier for people to buy and sell agricultural land. Whether it also means that it is easier to set up industries on anywhere you want, the answer is not clear, because the answer is you still have to follow conversion of land use, and conversion of land use is not an easy thing to do because there are certain procedures that you need to follow. So that's in summary. Thank you for joining us today and listening to us and asking some interesting questions. So as I mentioned, please do write to us if you have any more questions. Thank you and have a good afternoon.